we're going to go right into our questions right now. It looks like I'm 1 minute over. It's just about 12:01. It looks like we have, gosh, a lot of questions today, about 30 questions. So we'll dig right into our questions. Our first one is from a board member. Can an HOA issue a violation for any reason if a board member observes and/or documents it, but the property manager doesn't? Is the board member's name subject to disclosure if requested by the violator? We do provide a complaint form for residents to file violations, which include applicable statute 33-1242 for disclosure. Okay, so yes, I do feel that the association can issue a violation based upon a board member observing the violation. Ideally, it would be best if a board member or a property manager, one of you has to, see the violation. Now, if it's an owner, I would need to have, like evidence, like a photo or something to support the violation before I would advise the board to send out a violation letter. Is the board member's name subject to disclosure if they're the only person that, saw the violation and it's in the association's records? Yes, they would be. Same thing with an owner. So if the violating owner wants to know who made the complaint, the association does have to provide that information as to who witnessed the complaint. Okay, next question. Let's see. Is the association required to have an audit done yearly? So yes, an association that's a planned community or a condominium has to have an audit, review, or compilation done every year. The audit only needs to be done by a CPA if your documents require it to be done by a CPA. Otherwise, anybody could do the audit, review, or compilation based on the loose language of the statute. And if you want more information on that, our top 10 cheat sheet on our website has the statute number and a little bit more analysis on the audit for you. And remember that the audit, review, or compilation for like the 2024 books will need to be completed by June 30th, 2025. Okay, next question. Our master association, maybe it says should be held the annual election of the board. There were 3 openings, but only 2 candidates on the ballot. There was no line for write-in votes, but members added write-in votes for 1 member in the blank space below the 2 candidates to fill the 3rd position. The board will not recognize this write-in vote because there was no line for write-in votes on the ballot and plan to appoint someone to fill the opening. Our governing documents state that the board members are to be elected by association members. Our master association appears to be in violation of those documents. What recourse do we have? This is a tough one. I'd like to see the ballot, but I do kind of feel like, if there were 3 openings and it said, hey, we're trying to find 3 members to serve on the board, I kind of don't really understand why they wouldn't accept the write-in candidate. If your documents prohibit write-in candidates or something like that, or, then maybe they'd have an argument on that, but I'm not hearing that based on the facts you gave me. So if I were you, I would request to see the ballots. I'd ask for a copy of all the ballots so that you get a copy of the people that wrote the write-ins. I would hire an attorney that represents owners to send a letter to your master association, telling them that, hey, we think these people were elected, and by appointing someone to fill these spots, you potentially are, violating the will of the people, and see what they do. If you want the name of an attorney that could help you to send this type of a letter, an attorney that only represents owners against associations, just reach out to me and I'll be happy to give you the name. I think that's probably the best way you should handle it. Okay, next question. Is the HOA required to obtain proof of insurance from owners and renters? If so, how often? Unless it's in your documents, you're not required to obtain proof of insurance. So, and if it is in your documents, it should be annually, but really you should have the association should be an additional insured on the owners and the renters policy so that we are aware if you cancel at any time during the term of the agreement with the insurance company. Okay, question 5. My association is hoping the CTA will go away. Since I'm a director, can I file just for myself? So I think we're all hoping the CTA will go away, myself included. Really the association needs to file. You can't just file for yourself. Um, you know, Everybody needs to comply with this law. So just putting one board member's name down and filing it, it's not enough. We need to have everybody who's on the board. Okay, next question. My HOA is not incorporated. Do we need to file for the Corporate Transparency Act? So there are a few exceptions. I don't know. I'd have to look at your association on a case-by-case basis. It's possible you do not have to file because you're not incorporated, but I don't want to give you that answer here based upon the penalties without looking at your documents. Okay, question 7. Our roads are private. We are preparing to enforce our parking rules. Our CC&Rs say no residents, guest parking only. Our signage says homeowner parking, guests only. Do we need new signs because homeowners don't include renters? We've been told warning notes under windshield wipers and towing are necessary because Phoenix doesn't allow driver window stickers and booting. Is that true? Our CC&Rs allow booting or towing, and warning signage will be ordered. Okay, a lot to swallow here. Okay, so you've got private roads. You want to enforce your parking rules. Our CC&Rs say no residents, only for guests can park here. But your signage says no homeowner parking, guests only. Well, I think you should change your signs to match what your CC&Rs say. That would be my first suggestion. I'm not aware that the city of Phoenix doesn't allow driver window stickers and booting. So I would recommend that you reach out to the City of Phoenix Neighborhood Services Department to find out what their policy is on that. Okay, question 8. Can the board legally have a member in an owner's meeting removed due to that person being verbally abusive, calling the board names, filibustering the meeting so that important information is not able to be given to the owners, and now most of the owners will not come to the meetings? Can we require a form to be signed by each owner stating they will be removed if they are verbally abusive? So we have a great cheat sheet on this topic called Dealing with Difficult Owners. You can find it on our website at mulcahylawfirm.com. Just click on the cheat sheet tab. I guess from my perspective, here's how I would handle it. If you have an owner who is being verbally abusive, perfect example here is the information that you're giving me. A couple things you could do. If you want to continue having in-person meetings, you could just announce at the beginning of the meeting what the rules are for the meeting and include that all these things that this person is doing, that if it happens, the person will be asked to be removed. If they won't leave, we'll call the police or we'll stop the meeting. That's one option, right? And then do it, like if you're going to threaten it, then you have to say, like, if this behavior happens, you'll get a warning and then you'll be asked to leave. If you won't leave, we'll call the police. You may have to actually do that once. Another option would be just convert your meetings to Zoom. And if somebody starts behaving like this, just mute them. Have the person who's controlling the Zoom call, just mute them or remove them from the meeting. And that will handle the problem right there. Can we have a form to be signed by each owner stating they will be removed if they are verbally abusive? The sad thing here is I've gone to probably, I don't even know how many meetings over the years, probably 10,000, 15,000 meetings. The people that are going to sign that form are going to be the ones that are behaving. The bad egg who's misbehaving will never sign that form. So I don't think that form is something that is going to work. Okay, next question. Can the HOA prohibit renters from subletting their condo? So it depends on what your documents say. By subletting, I'm guessing you mean like room, renting a room or something like that. So it needs to be in the CC&Rs, whatever you're trying to prohibit somebody from doing, whether it's, it has to be single family housing or, we're not going to allow, subletting. We see situations where, maybe it's a rental property and maybe 3 unrelated people are living in the property. And, that's not going to be considered a violation of the single family housing. So we'll have to kind of look at, what your issue is and what the CC&R say, and then evaluate what's the best way to handle it. Okay, question number 10. What is the process for obtaining a change in the plat map based upon the Superior Court decision in Sackett versus EPA? Just regarding the waters of the U.S. The case concluded that natural washes that flow solely from precipitation and having no direct connection to navigate waters are not subject to EPA jurisdiction. Original plat map contains restrictions that are in part based upon now supersede federal laws and regulations. I mean, I probably wouldn't touch that with a 40-foot pole. I don't think that you can probably change the plat map for that purpose. I have to look at it maybe a little more carefully, but I mean, the plat map has been in existence since the beginning of your association, and I'm not sure that you're going to need to change it based upon this, decision in the Supreme Court. But you're welcome to reach out to our firm. I can take a look at the plat map and see what it says and give you a more detailed opinion if you'd like us to. Okay, next question, number 11. What is the $15 late fee and when can it be charged? Okay, so remember, we're going to flip back to what we talked about earlier in the presentation today. So when we're asking the landlord owner for information about their tenant, right, there's only 4 things that we can ask for, like the names of the adults living in the property, how long the tenancy is going to be, the vehicle description and license plate numbers. And then we can charge them a $25 fee for providing us with that information. And it's, and if they don't pay that $25 fee after we've given them, 15 days to pay it, and we've got proof that we sent it to them by US mail, that we asked them to pay it, provide us this information, then we can charge the $15 late fee for them not providing the information. Okay, next question, number 12. Please clarify, HOAs cannot fine for failure to submit rental registration. We can only charge a $25 fee and then a late fee for not providing it of $15. That is correct. We cannot fine an owner, landlord, for not submitting the rental registration form or the rental registration information, right? And again, it's just that those 4 categories of information. If they, don't submit that and they don't pay the $25 fee, after we give them 15 days notice by US mail, if they don't pay it, then we can charge the late fee. Okay, question number 13. Can the assessment statement be mailed to homeowners so we can save on postage? Or can it be emailed to homeowners so we can save on postage? This is a really good question. This kind of is another law that was passed maybe 4 years ago that says that we have to send an assessment statement to owners, to let them see their balance. It really does need to be by US mail unless the owners have opted in to receive it by email. Okay, question 14. If the homeowner fails to register their tenant, can you restrict the tenant's usage of the common amenities? Ooh, that's a good question. I don't think so. And here's why. Because it says under the statute, let me go back up here. If we go back and look at the statute, let's see. So you go back and look at it. It says, except for the fees allowed to obtain the tenant's information, so $25, and any fees that relate to the use of recreational facilities, the association or its manager cannot assess, levy, or charge a fee or fine or otherwise impose any requirements on an owner's rental that are different from an owner-occupied unit in the association. I probably wouldn't. I would just stick with the $15 fine based upon what the statute says. I don't think I would go into, we're not going to allow you to choose the amenities because you didn't register the tenant. I think it's pretty clear that we can only charge that $15. So it's a little bit of a gray area, but I would lean on the side of being conservative and say, don't do this. Okay, question 15. Is there a limit on how many level 2 and sex offenders that can live in one 4-bedroom home? Wow, that's an interesting question. I am not aware of any sort of limit like that. You could probably check with your county or your city to see if they know the answer to that. Question 16. I am a board president with a board member who is behaving in a manner that is toxic, bullying, and backstabbing. This person has been spoken to about this behavior, and the person is not complying. Thoughts, please. Okay, so you're the president. You've got a board member that's a problem, right? My thoughts would be, is this person an officer? If they are, strip them of their officer title by having the rest of the board take away the officer title. If it's not an officer title, the only way to remove this person from office would be to follow state law. And that would require like a petition of the homeowners and then meeting of the membership to remove the person from office. I don't know how long their term is, but I think what you should do is maybe consider having your attorney come in and give a boot camp. Our firm goes in and does boot camps to help boards that have a high level of dysfunction because of someone like this. Another thing would be to have the attorney write them a letter regarding their behavior, or the association. The attorney for the association sending the board member a letter telling them breaching their fiduciary duties, you're causing a lot of problems. So I think there's some good suggestions there. So consider having a boot camp to bring all the issues to the table and talk about them as a board with maybe our firm to help you. Have me write a letter to this person regarding their behavior, reminding them that they're breaching their fiduciary responsibilities. Do a removal meeting to remove this board member from office. And the fourth option would be don't vote them out. At the next meeting, make sure that when their term's up, that they're not reelected by, bringing in a good candidate and trying to get other people to vote for this other candidate versus voting for them. Okay, question number 17. Our CC&Rs mention owners must park in garages. All parking spaces shall be available for use by members of owner's family, their guests, and their tenants. But in the rules, the following is stated. Any vehicle that is parked in violation of the parking restrictions identified in the CC&Rs and association rules is subject to towing. They give each owner a visitor pass. If you don't have a pass, the HOA is towing without notice. Is that a valid policy? So your CC&Rs say owners got to park in the garages. Parking spaces can be used by members of the owner's family, their guests, and their tenants. But the rules state that any vehicle that is parked in violation of parking restrictions is subject to towing. Okay, I don't think that the towing is a valid policy, just being in the rules. So that would be my advice. I would not be towing based upon that only being in the rules. I think that is not good legal justification, and the board should not be doing that. Okay, question 18. What can an HOA do if the person who is committing a crime is a homeowner? SWAT was called and he was booked and pleaded guilty. Okay, well, I'm guessing maybe this person's going to jail if they pleaded guilty, but who knows, maybe not. So if the person is committing a crime and they're the homeowner, you can fine them. Would be one thing to, think about for the nuisance that's being caused. Maybe you could get an injunction compelling them not to do it. I'd probably need to hear more. It's concerning to me that the SWAT team is out there and this person is in jail. They pleaded guilty. Maybe they're in jail. Maybe they're going to be back, and you just want to make sure it doesn't happen. But I think finding them for that occurrence and setting expectations going forward will be important. So reach out to my firm. Maybe I can help with that. Okay, next question 19, does an owner's designated agent or a renter have permission to attend board meetings? So owner's designated agent, in writing, yes, they can attend a board meeting. Renter, no, they cannot attend a board meeting unless the board allows them to gratuitously, or unless the renter is appointed in writing as a designated agent to go to the meeting on behalf of the owner, and that form has been provided to the board. Okay, question number 20. Our condominium is midway through board elections. The association altered candidate applications by removing all paragraph breaks without candidates' knowledge or consent. This was a secret policy which caused compositional errors in some candidates' biographies. Management and board refused to address this or issue corrections. What are options for candidates' remedy in the case of harm to one's candidacy? Well, just because they took out the paragraph breaks, I wish they hadn't done that, but they may have done it for spacing to try to fit it all on one page or something. I don't know. I think the candidate's remedy would be send out another statement on your own dime to, make a better presentation as to, whatever you want to say to the community. But I don't think that, you can force the association to do that unless they gratuitously agree to do it. Okay, question number 21. For 1 and 2 night renters who are violating the rules, how can we keep up with violation notices when it's happening frequently? Is there a single violation notice and then after that a fine for each tenant who is breaking the rules? I think on this one, you really need to kind of take a peek at like, okay, we need to get in touch with the owner. We need to have a face to face or one on one phone call and just explain to the owner that, okay, like we know you're having people coming in and out here on a nightly basis. This is what you need to do with the association. And you need to pay the $25 fee. You got to give us the information, on your 1 and 2 night renter. And if you don't, here's what's going to happen. We're going to file a lawsuit against you. We're going to go to the company that is, doing all these rentals for you, whether it's VRBO or whatever, and we're going to subpoena all the records. And you're going to have to go back and pay, all these fees and then also pay all of our attorney's fees. So I think the best way, it's hard to, keep track of, okay, the neighbor saw somebody coming in, on Saturday and left on Tuesday, and then another neighbor. It's too hard to do it that way. You have to get buy-in from the owner to make this successful. And so I think the best way to do that would be to have the attorney reach out to the owner, let him know these are the violations, and this is how much it's going to cost you if you don't comply, and let them know that we know you haven't been complying, but this is what we're going to do unless you comply going forward. Next question, 22. Can a maximum dog weight that is written into your CC&Rs be upheld? Or will that be something that is against their rights? This question is only for standard pets and not in reference to service dogs or any other type of special needs animal that a tenant or owner would need. So yeah, I think if there's a maximum dog weight that can be upheld, is it a good idea to be enforcing that? I guess that's kind of an eye of the beholder. Dogs gain weight sometimes over time, or dogs gain weight if they have a health issue. And pets are kind of like almost like children for people. So to tell somebody they have to get rid of their pet could be really a difficult situation. And so from a practical standpoint, can you enforce it? Are you willing to enforce it? Is it going to cause a lot of unrest to enforce it with an owner? Probably. But can you legally enforce it from a contractual basis? Yes. Okay, question 23. What is your opinion regarding having one of our security cameras installed on our clubhouse that would view the 2 pool gates only? The camera would view only people entering and exiting the gates. We have a board member who claims this is an invasion of privacy. I don't have any issues with that at all. As a matter of fact, almost every association that we know of has cameras at their pool. Or a great majority has cameras at their pool for a number of reasons. And so I don't have an issue with that. 24. I heard that TPT rental tax is being eliminated January 1st, 2025. Is this true? Will the landlord owner still need to report rentals if this is the case? Okay, so my office did some quick research on this for me, and we're going to be sharing with you a link on the transaction privilege tax. Based on my office's quick research, it is true that the TPT tax on residential rentals is being eliminated in Arizona, effective January 1st, 2025, but properties must still register their property with the county assessor's office. And then check the link if you want more information on this. Okay, question 25. Looks like we have a total of 33 questions, so only a few more. If 2 out of 3 board members request a special meeting be held and the specific topic is RFP review and decisions, but the 3rd board member and management company do not acknowledge the request, can the meeting be scheduled, noticed, and held? So my opinion, I'd have to look at your bylaws, but yes, I do think a majority of the board can call a special meeting and you should be able to move forward with it. Okay, and just do it without them. If they're not willing to come, or they're not willing to acknowledge it, then you just post it at the property and make sure you post the notice of the meeting and an agenda. And then state with particularity what specifically is going to be discussed on the agenda. Okay, question 26. How long do board meeting minutes need to be saved for? We have a great cheat sheet on this called document retention or records retention for associations. Meeting minutes are permanent and they should be saved forever. And so do not terminate, do not get rid of those. That's the history of the association. Keep those forever. Question 27. We had a current board of 5 members and 1 board member just immediately resigned, leaving us with 4. Do we have to fill that before the end of the term? I mean, it depends. It depends on, do your documents say you must have 5 board members? Like, how quickly is your annual meeting coming up where you could, elect somebody for that spot, or do you want to appoint somebody? There's a lot of variables. So do you have to fill that? Probably not, but I wouldn't leave that open for too long. And I want to look at your documents to see what your documents say about this. Okay, question 28, regarding for sale signs in common areas. A realtor is referencing a statute saying that owners in a condo complex own an undivided interest in the common areas, so they can put a for sale sign out in the common area. The statute states that HOAs can't keep owners from putting up signs on their private property, which we don't believe includes the common areas. I know this has come up before, but the realtor is saying we need to get a letter from the attorney or they won't remove the sign. What are our remedies? Okay, so I don't know specifically if you're like a condominium or planned community, it probably doesn't matter, but okay, if a realtor, okay, so here's what the law is on for sale signs, and we have this on our top 10 cheat sheet if you want more information on that. Top 10 laws pertaining to association, Arizona Community Association law. Okay, so each owner can have a for sale sign on their property. They cannot have it on common areas. Okay, if it's a condominium on their property, means in their window, or maybe in their limited common area. But it doesn't mean that you can put it on the corner, leading into the association, etc. So if the realtor put it on the common areas, you want to get along, but you can also say, if you don't remove your sign by X date, this is what we will be doing. If you want the statute number, go to our cheat sheet. Like I said, our top 10 cheat sheet, and it's listed on there on the back side of the number 7 or 8 on our top 10 cheat sheet. So you can remove it because it's on your property, but you probably don't really want to do that because those signs are heavy and expensive to move. What I would say is tell the realtor to move the sign by X date, and if they don't, then you will have it removed. Okay, can we have the public roadway vote at our annual meeting? So good question. Yes, you can. Number 30, what is the best approach to deal with homeowners who refuse to comply with the community sign guidelines or new laws regarding the removal of election signs on their property? As a board member, we are responsible for upholding the guidelines, but we do not want to turn this into a potential media fiasco. Amen, I agree. I would give them a reasonable period of time to remove the signs, and so I would say, before Thanksgiving to me, I mean, the national election took place quite, first week in November. So the signs should be down. You may just want to make an announcement via the community. If you have a lot of people that still have flags up or signs up or something like that, just remind them that the law says that the signs should have been removed by now. And if they don't remove that, they will be receiving a violation letter. And I don't think that should be a potential media fiasco because the election's over. And even the cities, all the signs that we had all up in city corners and all that stuff, that those are all should be removed by now too. Okay, question 31. Do the renter name, contact, duration, and car info rules apply to short-term rentals that may only be there for a few days? So short answer, yes. Question number 32. Please clarify if an HOA needs to proceed with an amendment in order to fine an owner whose renters are causing our HOA to receive constant complaints about aggressive behaviors. Another has suspicious drug usage, selling activity, and the police have been involved. So I don't think you need an amendment to fine an owner if you have a renter who's causing a nuisance. I mean, 99.999% of CC&Rs have a provision in there that talks about nuisance. And so I don't think you need to do an amendment to deal with this issue. It's probably already in there. Okay, question number 33. What can be done after a denial of a paint color when the owner appeals without making any change? We are a tan, desert-colored community in general. We do have designated color palettes, but we also allow submitted colors if approved. Owner is asking for an almost navy blue main home color because light blue has been allowed in the past, but not on a designated color palette. Well, I mean, paint colors are always a nightmare, especially if they've already painted it because it's expensive to paint. But I mean, I guess what can be done, you can, live with it as a board. You can force them to repaint it because they didn't get approval and it's not a color that would have been approved. You can, by forcing it, I mean, you can go to Superior Court, get an injunction compelling them to paint it. You can go to the Arizona Department of Real Estate and have an administrative law judge rule that what they did was illegal and it needs to be repainted. You can let them keep it and say when you sell your house, it has to be repainted. I mean, there's a lot of different things that you can do. Legal, be more accepting of it if that's the route you want to go, and just say when they leave, they sell their house in the future, repaint it, it needs to be repainted. I mean, there's a lot of different options here. Okay, and our last question, number 34. Our HOA has not had an election for years. There was a majority vote when 2 members were unable to vote to sign up for a property management company. The 2 members have been reinstated. It was due to delinquent dues, but there still has been no vote. And they continue to contract for an additional year with the property management without a vote. The property management company now calls themselves the Board of Directors. What can be done? Okay, that sounds like this is very dysfunctional. So, I mean, if I were in your shoes, I would write a letter to whoever's acting as the board and tell them that you want to have an annual meeting. We're required under Arizona to have an annual meeting. Ask them to have an annual meeting, in January, because right now we're kind of in holiday alley, and I don't think it's a good idea to ask for it right now until the beginning of the year. So ask now. We're demanding an annual meeting for our association. We haven't had one. We're asking that it be conducted in January or February 2025. And if you don't, notice it, we will notice it as homeowners. And then after, it's noticed and a ballot is sent out, then you got to go door to door and get people to vote, because it sounds like they haven't had an election for many years, maybe because they haven't been able to get a quorum. So you're really going to need to find good candidates to run and then get people to vote to get them elected. This is our last Tuesday neighborhood services, Virtual HOA Academy of 2024. We've had 11 classes so far, but this is our last Tuesday session. So our last class of the year is class number 12, and that's going to be held as part of the 2024 Virtual HOA Condominium Academy. It's going to be held in collaboration with our firm's live virtual First Friday event, and that will be taking place on Friday, December 6th at 9 a.m. This will be our last virtual class for 2024. Where has the year gone? Crazy how fast 2024 has gone by. So I would like to wish all of you a very happy Thanksgiving. Take care.